The Honorable, the Judges of the United States Court of Appeals for the Fourth Circuit. Oyez, oyez, oyez. All persons having any manner or form of business before the Honorable, the United States Court of Appeals for the Fourth Circuit are admonished to draw nigh and give their attention, for the court is now sitting. God save the United States and this honorable court.
All right, please be seated. All right, we'll start with our first case, Speech First versus Timothy Sands. And Mr. Hassan, whenever you're ready, we're pleased to hear from you.
Good morning, Your Honors, and may it please the Court. The question in this case is not whether universities can facilitate conversation about bias or impose reasonable time, place, and manner restrictions on campus activities. They clearly can. The question is whether the two policies the university has adopted here.
I'm going to ask you to speak up because we have fortunately, we're social distancing, but I want you to speak up.
Absolutely, Your Honor. The question is whether the two policies the university has adopted here, the bias-related incidents policy and the informational activities policy, go too far by chilling student speech and restraining expressive activity. They likely do. The university is not using the bias-related incidents policy to facilitate conversations. It has adopted a formal definition of bias-related incidents. It has adopted a formal process that asks students to anonymously report each other to a team of university administrators who open investigations, ask for meetings, threaten referrals to disciplinary authorities, and keep logs of all complaints. The university's own exhibits in the district court state that the purpose of the policy is to, quote, eliminate biased speech. This regime does not facilitate speech.
The university is contending with respect to the leafleting that it has tables all over campus and that the approval process is a fairly perfunctory one. I realize that's only one aspect of the policy that you're challenging. But what is your response to the general point that they're making that tables are widely dispersed and that that there's still old-fashioned ways of communicating like billboards, and that approval is to have a petition or something at a table is perfunctory, that they're all approved as a matter of course. What's your thought about that?
Thank you, Your Honor. Our response would be that there's nothing in the policy that says that. The policy on its face says that you need prior written authorization. If the university, for example...
Okay, so the question is, do we rely on the policy or the depositions that indicate how the policy works? What's the operative thing here, the policy or the depositions?
Your Honor, I would say it would be the policy. In North Carolina, right to life, in your opinion in that case, Your Honor, the court held that post hoc litigation representations are not binding on the court and do not otherwise outweigh a facially restrictive policy on speech. And that's the case here.
Was that a preliminary injunction case?
I believe it was, Your Honor. I have to double check that, but that's my understanding.
Because I guess what Judge Wilkinson's question is getting at is why shouldn't we just look at the policy that's apparently, at least on the face of it, has been applied in practice that suggests that there really isn't anything arbitrary or capricious about it, that there's a process for getting approval, which is generally granted, I think, in every case, and that there essentially is a lottery system, which is restrained simply by the capacity of the university to accommodate the various groups, but there's no content subject matter restriction.
Your Honor, respectfully, I do think there is some content subject matter. So for example, you need prior authorization to distribute literature about informational activities. You don't need that to distribute literature for advertising.
For what? I'm sorry?
Advertising.
Okay.
So if, for example, if you want to hand out leaflets about the upcoming election, about a ballot measure, you need prior written authorization. If you want to advertise about a fraternity rush week event.
You just have to talk up. You're dealing
I
with
apologize, Your Honor.
old ears.
No, I apologize, Your Honor. Is this better, Your Honor?
Yes. Or maybe, can you pull the microphone closer to you because you're tall?
Yeah, sure thing. All right. But if you wanted to hand out literature for a Rush Week event, for example, advertising, then you don't need approval at all. So the difference between those two things are the words written on a piece of paper, which we would believe would make it content-based, Your Honor. And
I'm
because of
sorry,
that,
I didn't understand your distinction. One is advertising and one's not. And if you're talking about your beliefs, that's advertising them. I just don't get, try me again on that, okay?
certainly. So the policy requires prior written authorization
Right.
to distribute literature.
Right.
That's informational in nature. Say, for example, something about a ballot measure in an upcoming election. But you do not need prior written authorization to distribute literature that is advertising. If that makes sense, Your Honor. So it's the same handout, but the content is different, and one requires prior written authorization and the other doesn't. But if I may, go back to the bias-related incidents policy. The court, the question.
The Sixth Circuit cases, I don't think they did. They had one of these bias committees before them. But my recollection is that the leafleting question that's presented here and the tables and everything, was that an issue in the Fifth and Sixth Circuit cases? Because it seems to me that we're certainly courting a circuit conflict if we uphold the bias committee, but as far as the leafleting question was concerned, was anything comparable presented to those other circuits?
No, Your Honor. The speech first cases in Schlissel in the Sixth Circuit.
So the conflict would be with respect to the bias committee.
That's correct, Your Honor. The
Isn't
Fifth,
there already a circuit conflict, though?
the Seventh Circuit took issue with the factual record in that case. If you look at Judge Brennan's concurrence in that case, he wanted declarations from the students, and that's the record that we provided here. But when you do a one-to-one comparison on the facts and the record between Cartwright in the 11th Circuit, Schlissel in the 6th, and Fendez in the 5th, all three of those are uniform that these types of policies objectively chill speech. And they do
The
that.
holding in the Seventh Circuit was?
They found that a lack of standing
Right.
because there was not a strong enough factual record to show that speech was being objectively chilled.
And I think that's the argument here, is it not?
Yeah, to a large extent, yes,
So
Your Honor.
there is a split in the circuits already about the argument that is at issue here.
Yeah, I think that's probably.
Right. Okay.
My understanding was that that the Seventh Circuit held no standing, and that the Fifth and Sixth Circuits held that there was standing. And as I understand it, the argument for standing that you're making is that these are students at the university. They are subject to the policy. And that when we look at injury in fact, the Seventh Circuit said, well, there need to be particularized definitions. But as I understand the Fifth and Sixth Circuits, they were saying, no, that this case law to support it, that self-censorship on these volatile topics is in fact due to the policies, and that qualifies as an injury in fact. The self-censorship is an injury in fact. Is that your argument?
Yes, Your Honor, that because the policies, if you take a look at comprehensively what they do, the anonymous reports, they summon students for meetings on a
So
team that has...
you don't necessarily need to wait for the authorities to say, well, this, what you've just said is out of bounds and the rest. It's a question of the reaction to these sorts of policies and being called on the rug by the dean's office and everything is enough to create the policies themselves, create self-censorship under the First Amendment. And that was the argument that persuaded at least several other circuits, the fact that there was indeed standing here.
That's correct, Your Honor. That's our position as well. And you know, this court in Cooksey held that in a pre-enforcement facial challenge, you don't need to wait and risk punishment in order to be able to challenge a policy that facially applies to speech and has an objectively chilling effect.
Can I ask you, excuse me, about one of our more recent precedents, Abbott? And isn't there language there that a threatened administrative inquiry does not constitute a First Amendment injury? Doesn't that seem to fit exactly this case?
So we believe Abbott is distinguishable, Your Honor. And I believe you're on that.
But that's the
Right,
language. I quoted the language.
Yes.
That's not distinguishable.
Yes. But the court in Abbott did say that the facts, that its holding was limited to the facts of the policy before us, or the facts before us, I think was the quote that the court used. It also described the situation as a, quote, very unusual First Amendment challenge. And the reason for that is a student was asked permission beforehand to hold an event. The university said, by all means.
Yes.
After people complained, the university said, well, we weren't physically at the event, so we don't know if it happened as approved. And so they asked for a single meeting to clarify the facts, and they even emphasized that they were not investigating the student. They were in a pre-investigation stage. Here you have an entire apparatus that is affirmatively designed to, quote, eliminate biased speech. The university describes it as reprehensible. They describe biased speech as reprehensible.
Well, that's one way of looking at it. I suppose another way of looking at it is that the policy is in place to mediate disputes among students. Is it your position that the universities and administrators have no role in mediating disputes among students?
Well, certainly the universities have to be able to resolve disputes, but it can't be the case that you're trying to facilitate a conversation if you're soliciting anonymous reports. There's no one to have a conversation. There's nothing to mediate if someone's reporting you anonymously for having an unpopular opinion about whether it's immigration or gender identity issues or any of the like. And the university has even referred a student to student conduct from the BRT for an unpopular position about immigration, which is exactly...
And what happened then?
They ended up not charging, but...
No one's ever been charged, right?
Well, the disciplinary records are...
Well, there's nothing in this record...
confidential, but there's nothing before us, and part of that is because those records would be confidential under FERPA.
Well, we know 2 people have been referred and nothing happened.
Based on the university's representations, yes, Your Honor.
Well, are you suggesting that the university has lied to you?
No. That's not at all what I'm
Okay.
trying to say. Just trying to say there's nothing in the record before us. and that we learned about those two things from the university's brief. But, as the court held in Cartwright in the 11th Circuit, which I might add was a case where the university and the district court described that policy as precisely the same, I think was the term that they used, as the BIRT, after the district court, in that case, held that speech first lacked standing. And we would agree that those policies are basically carbon copies of one another. And what the 11th Circuit held in Cartwright was, after reviewing the Supreme Court's decision in Bantam Books and Akwedi and other cases, that universities can chill speech without directly prohibiting anything. And that's the situation where we are here. And even in the Seventh Circuit, Judge Brennan's concurrence emphasized that process is punishment is not a platitude. And the other, Killeen and Schlissel also held the same.
All right, thank you, sir. You have some rebuttal time.
Thank you, Your Honor.
And we will now hear from Mr. Hurd. Mr. Hurd, I'm going to ask you to speak up too, because I'm interested to hear what you have to say.
Yes, Your Honor. May it please the court, let me touch briefly on one of the errors that opposing counsel has made in his opening remarks.
Mr. Hurd, I'm sorry to interrupt you, but before we get to that, there's a motion pending to dismiss this action entirely based on developments of record and their competing affidavits. Could you talk briefly about that? Because it seems to me that the bottom line here, that there still at least remains one student who is not yet graduated. And although you surmise that he or she may well be gone by the end of December, we really have no way of knowing that. So why doesn't that really end the prudential standing inquiry?
Well, Your Honor, we do have a way of knowing that this student is likely to graduate in December. They have said that to this court in a sworn affidavit. Therefore, it is most likely that by the time this court finishes its work on this case, that student will be gone.
You underestimate the efficiency
Yeah,
of
we're
the court.
Speedy Gonzalez up here.
In any event, Your Honor, if the court decides to proceed to the merits, Virginia Tech should prevail. In their reply brief, and again this morning, they misquote the record. They say Virginia Tech's stated purpose is to eliminate biased speech. And in their brief, they point to JA 369. But that's not what JA 369 says. It talks about eliminating acts of bias, not speech. And on the same page, it says this, quote, effective and appropriate response.
How can this not be said? It's not just a conduct regulation. It talks about if there's bias, somebody can be reported for biased speech.
Your Honor, let me.
Excuse me, Mr. Hurd. There's no limitation on when saying you can't just you can't report someone for just pure speech.
Well,
and then the policy 5215 talks specifically about the distribution of literature and informational activities. Now, that is speech. It's pure speech.
Your Honor, let me address those separately. First, with respect to informational activity, the policy says nothing about giving any discretion to Virginia Tech officials to make any kind of content-based decision. The evidence shows they do not make any content-based decisions.
Where in the policy does it draw a line between conduct and speech?
Your Honor, the policies are very different. There's the bias response policy and there's information activities policy, the leafleting policy, if you will. Now, this morning, opposing counsel has tried to introduce a new argument saying there is a difference in how we treat handing out political flyers versus handing out advertisement. There's no difference.
Where is that in the policy?
Well, Your Honor, the policy for advertising, and I take him to mean like advertising pizza or something, that is not part of the informational activities policy that they are challenging in this case. That is found in a different part of the policy, JA 228, that deals with advertising.
Well,
So
I
the
don't.
court ought to disregard that argument.
Mr. Hurd, I don't see anything in the policy that rules speech off balance. And the whole difficulty, and it's really fundamental here, is that you've got a university which is supposed to be a place of dialogue for the students who attend it, and it's all channeled into a pre-approval process for the to the state. In other words, you've got to get the state's permission before you can engage in First Amendment activities.
Your Honor, that is not correct.
It is correct.
That is inconsistent with the record. You have to get permission to reserve a place to pass out leaflets.
Right, but let me
But not to speak, not to speak.
Yes, excuse me, Mr. Hurd, you keep interrupting me.
Excuse me, apologize, Your Honor.
This permission, this language is so vague, and you're saying, well, trust us, we're gonna do it fine. Well, we're told by the Supreme Court that we're not to just turn over the First Amendment to a sort of a trusting process, and the difficulty here is that you've got a policy where there's an unnamed official operating under vague and indefinite policy.
Your Honor, if I may, let me focus on the BERT issue, the bias response issue.
Excuse me, there are two policies at
Yes.
issue here. And I think it would be helpful for me, anyway, if you could tell me what policy you are addressing,
So
one at a time.
let me address first the bias response policy.
Okay.
This court has said on multiple occasions that in order to have standing, you have to have a credible threat of enforcement. Now, there is no credible threat of enforcement here because our bias policy does not prohibit anything. Our bias policy team cannot discipline anyone. That's what Judge Urbanski found, and they have not challenged that. What they have said instead, oh, well, BERT can refer a case to law enforcement or the student conduct office, and that
Excuse me, can't anyone do that?
certainly they can.
So that would mean if that gives you standing, you have standing against the world, I guess.
Well, I think that's probably true, Your Honor, but here's the key point. In order to have a threat of enforcement, you first have to have a rule to enforce. And we have no rules that prohibit protected speech. And the power to refer cannot chill speech here because there is no basis to refer protected speech here.
Mr. Hurd, do you think that there needs to be a power to enforce in order to satisfy, to support a First Amendment violation simply for chilling speech?
Well, this court has found that in order to have chilling, you have to have a credible threat of enforcement. The court has said that in Abbott and in some other cases. So it's not that chilling is a freestanding thing we look at and do some kind of psychological analysis. That's what they may have done in the Schlissel case in the Sixth Circuit, but that's wrong. You have to have a credible threat of enforcement. There is no credible threat here because there are no rules to violate for protected speech.
Is that a merits determination or a standing determination? Because we're here on standing, right?
It is a standing determination. In Abbott, this court said...
Abbott wasn't a standing case. It was an adjudication on the merits.
But the court also said a credible threat of enforcement is critical. Without one, a punitive plaintiff can establish neither a realistic threat of legal sanction if he engages in speech in question, nor an objectively good reason for refraining from speaking and self-censoring instead. That was a comment about standing in the context of Abbott, and the court has said it in other cases as well. Now, they realize there are no rules that prohibit protected speech. They realize, whether they admit it or not, that BERT can only refer to law enforcement or student conduct if there's a violation of a rule or a law. They mentioned two mistakes that were made. And as Judge Marks...
Mr. Bert, how can this possibly not have a chilling effect when something you say can give rise to an anonymous report and an anonymous accusation to this committee, and then you're going to get a letter from the dean of students or somebody in the dean of students' office calling you on the carpet and saying, explain yourself.
Probably
And
not.
excuse me, how can that not be a chilling effect? You have to consider it from the standpoint of students who know if they speak out on a controversial subject, be it transgender issues or Black Lives Matter issues or illegal immigration issues, they're going to be called, they're going to be reported by somebody, they're going to be reported anonymously, and you're going to receive an invitation or invitation is too mild a word, you're going to receive a letter from the dean of students saying, come before this committee and explain yourself. And then further, there is going to be a report in the dean's files to be referred as needed to a student council or to some disciplinary body. And this seems to me, if this isn't a chilling, this whole apparatus, if this whole apparatus doesn't exert a chilling effect, I'm hard pressed to know what does.
Your Honor, with due respect, the record is much different than that. There are very rarely does the dean invite someone to come to a meeting, and those meetings are voluntary. Now, they say, well, nobody would regard the meeting as voluntary, but let's look at what happened in the killing case, the Seventh Circuit. That court found that when students were invited to a meeting by the Illinois bias response team, a majority either did not respond or declined to meet. That's at 968 Fed 3rd 633. So the average student does not regard these meetings as mandatory. And if a mandatory meeting that was going to talk about, well, did you violate some policy, if that mandatory meeting is not unduly chilling, then neither is a voluntary meeting where there cannot be a referral unless there is a reason to believe you violated the law or some rule. They've not pointed to any rule prohibiting speech in this whole thing. Now, let me give you an example, Your Honor.
It's your burden to show that it's not their burden to show a rule prohibiting speech. It's your burden to show that you have a very emphatic policy permitting speech.
Your Honor, we have such a rule. It appears on the first page. It appears on the first page of our brief that we view every complaint through the lens of the First Amendment. Offensive speech or not.
But where's the policy?
The policy is there, Your Honor. It's cited in the first page of our brief. That is the policy. We view every complaint through the lens of the First Amendment. That's why so few ever wind up resulting in an invitation. Let me give you, Your Honor, an example.
You know, that is simply a plea from a state bureaucracy to say, trust us, we're going to do well. But the point is, the plain language of the policy is what governs here.
Let me give you
the child evangelism case, they make that clear.
Your Honor, this is not.
What this whole thing and what your argument is saying is that we're going to be good people. We're going to administer this in a fair-minded way and everything. But when I look at the combination of a prior restraint coupled with the vague language and the bureaucratic discretion that resides in the administration of it, it's a combination of a lot of different First Amendment red flags.
Your Honor, if I may, the child evangelism case, they have cited not in the context of the bias response policy, but in the context of the informational activities policy. They pointed out that in child evangelism, the policy of that school board was unconstitutional because they would review in advance your flyer to see if it could proceed or not. We don't review anyone's leaflet, and this is the informational activities policy again. We don't review leaflets in advance to see if we like them or not. It is a first come, first serve approach, a reservation system only. That's what the judge found. Judge Urbanski found. Now,
Before, if I could just ask you this question, it is like child evangelism to the extent that somebody who wants to distribute these must come to you, the ruling body, and get approval before they, so it's a prior restraint of some sort, isn't it?
well, so in child evangelism, the school itself was doing the distribution.
I'm very familiar with child evangelism.
Yes, Your Honor, I understand. So is it a prior restraint to reserve a table in advance? Well, yes, it is. But a prior restraint is lawful if it is a reasonable time, place, and manner requirement, and this one is. To say, look, we got 800 organizations, we got 38,000 people, we're trying to figure out how to administer this thing in a reasonable way, and so, yes, you come in and say, hey, I would like to have a table at the end of the drill field next Tuesday.
You can make a reasonable policy out of, you say, oh, there's so much congestion and this and that. You can make a reasonable policy out of time, place, and manner restrictions, which says you can't distribute literature in the hallways. You can't distribute literature at the doorway to the hallway. So there are plenty of ways in which you can administer this.
Your Honor, that's correct.
This policy. And what bothers me is I think back to the founding of this country and the importance that leafleting and petitions, which are explicitly protected in the Constitution. Did the founders of this country and the people that wrote our Constitution envision a system where people had to get pre-approval from the state before they could say anything controversial? It is just...
And that is not our policy.
Mr. Hurd, please. This is fundamentally at odds with the principles that this country would produce, which was that prior approval for speech subject to loose discretionary standards administered by unnamed bureaucrats, subject to anonymous reporting of one student or another. Is this supposed to be, is this what a university is supposed to stand for? Is this, I don't get it.
Well, Your Honor, if I may, obviously, if the state of Virginia required prior approval of the content of leaflets before passing them out, that would be unconstitutional. If you said you can't pass out leaflets on the street of Richmond without prior approval, that would be unconstitutional because that is a traditional public forum. The university is not a traditional public forum. Now, there may be other ways to have a reasonable time, place, and manner restriction on passing out leaflets. And if you or I were on the board...
It's not a traditional public forum in the sense of a sidewalk or a street or a park, I grant you. But it is a public forum for the students who are part of the intellectual life at the university, which one would hope would nourish them. And it is a designated public forum for not just the public at large, but for the students. And the Supreme Court has repeatedly said that the university for the students themselves is supposed to be a place where speech, values, and dialogue are honored and not chilled and subject to pre-approval by university authorities.
Well, Your Honor, again, that is not what this record is. We do not look at flyers in advance to approve their content. The policy does not give us that authority, and if you thought the policy was ambiguous on that question, then you should defer to practice, and you should defer to the presumption that officials will discharge their duties correctly. Let me give you an example, Your Honor, of something that would merit an invitation.
What about the solo speaker? You have to be a member of a student organization in order to get pre-approval. Now, suppose a single individual wants to leaflet at a crosswalk. Justice Kennedy made the specific point that the First Amendment is not meant simply for people who combine in groups under an RSO. It's meant for the single person who may have an unpopular point of view, but that person is entitled to be protected in leafleting or whatever at a crosswalk. You don't have to have everything go
Well,
through a pre-approved table.
Your Honor, the Martinez case would dictate a different result. But let me, if I may, give you an example of something that would merit an invitation to come to a meeting. In this court's decision in the Iota Xi case, 1993, the court dealt with a college fraternity that held an ugly woman contest with one guy dressed in blackface. The court said that was protected speech. And if that happened at Virginia Tech, we would treat it as protected speech. But we would probably want someone, perhaps the Office of Greek Affairs, to invite those students to come in for a conversation about why that speech is wrong. But according to Speech First, we could not even make that invitation. Even the possibility of making that invitation would violate the Constitution in their view. And that cannot be right. We are an educational institution, and we would not be doing our job if we did not try to show these students why that kind of speech was a problem. And that is part of our
Thank you,
academic
Mr.
freedom.
Hurd. I'm going to ask each of my co-panelists if they have any questions, in which case we'll give you some extra time.
Thank you, Your Honor.
Judge Diaz. We have no further questions. Thank you.
Thank you, Your Honor. We ask the judgment below be affirmed.
Mr. Hassan, you had some rebuttal time.
Thank you very much, Your Honor. I'd like to briefly address a few points about the BIRT and then a few points about the informational activities policy. One, my friend over here has emphasized that they don't formally punish students from the BIRT, but never addressed the case law in the Second Circuit and the Supreme Court that we cited in our brief, showing that formal prohibitions are not required to chill speech. And that's exactly what the bias response team does.
So, Mr. Hassan, do you think that our Abbott decision, that was wrongly decided? Because that seemed to support Mr. Hurd's position that there has to be a credible threat of enforcement.
I think Abbott is distinguishable, Your Honor, for the reasons that I expressed during my opening.
Well,
And I think
you certainly did distinguish it, but I don't know that you distinguished it in a way that really makes a difference to this case.
But I think the difference between the two is in Abbott, it was the normal disciplinary process, and they had basically it was a fact-finding single meeting, pre-investigatory meeting, whereas here, if a student says something about anything remotely controversial, including in class, they could be brought in for a meeting that includes the director of student conduct. And as the 11th Circuit pointed out in Cartwright, and that's 32 F 4th at 1124 note 5, the average student would no more think that that kind of invitation was voluntary than a teenager would if their parent said, please clean your room, or can you please clean your room? That was the exact example that the 11th Circuit used in that case. And third, I would emphasize that if we just changed the actor from the university to the city, and the type of speech from biased speech to patriotic speech, no one would think that the city of Blacksburg could have a patriotism response team where they summon people in for meetings for saying anti-American speech. And if they couldn't do that in the city, they certainly can't do it.
But you assume that you have to go to the meeting. As I read the record, you weren't required to come to the meeting. That's why this whole policy is interesting, but it doesn't seem to have much bite to it. And you're all about worrying about potential bite, chilling, right? And if it doesn't have any bite, how can there be chilling?
Well,
Am I right that you don't have to come to the meeting?
that is, the meeting is technically voluntary, Your Honor, but I don't,
Oh, well, do we have anything in the record that says it wasn't voluntary in some situation? I mean, technically, we've given it a little bit of a pejorative spin there. The meeting is voluntary, right?
yes, Your Honor. But if you place yourself in the shoes of an 18 or 19-year-old student at a university, and you get a letter from the dean of students asking you to meet about your speech, I imagine most 18 or 19-year-olds who are, freshmen at a university would feel pretty obligated to go. And in Schlissel, the
It
sixth,
said, would you like you to come to a voluntary meeting about your speech? You have dealt with more docile 18 and 19-year-olds than I have.
well, Your Honor, I think the Sixth Circuit in Schlissel pointed out that the referral power that the bias response team had there.
But I asked you about that earlier too. I didn't think the referral power was any more than any other citizen could have. You can, or any other member of the community.
Well, certainly anybody can report misconduct, but it's a different when you're dealing with the state, summoning you for your speech and referring you versus a peer. The power dynamic is widely different. I see that my time is running out, so very quickly, just to touch on the informational activities policy. The university emphasizes that they have disclaimers about protecting students' First Amendment rights, but the Supreme Court said in U.S. v. Stevens that citizens are not required to rely on the noblesse oblige of the government to not restrict First Amendment activity when a policy facially does so. And lastly, I would just point out that Child Evangelism Center, I believe the court actually held that form analysis is irrelevant.
I have a question, sorry, before you sit down. So in the 11th Circuit case, the court, although it granted, it reversed on the standing issue, it remanded to the district court to consider the merits of the policy in the first instance. So, and I know you say that in this case it should be clear to us that you should win, but you're not arguing that simply because you would have made a showing on standing that necessarily ends the inquiry, right? I mean, we could agree with you with respect to the standing question and send it back to the district court, and the court could rule against you and find that at least on the merits, there simply isn't a substantial enough chill to warrant a First Amendment violation. Is that right?
There are definitely two different inquiries, Your Honor. That's correct. We think.
Isn't your standing argument tied to the whole chill?
There is.
If we find that there's insufficient evidence of chill, you have no standing.
There is a substantial degree of overlap, Your Honor, yes, between objective chill. If the court finds that this policy objectively chills speech as a matter of law, then because it clearly facially applies to protected speech, our position is that there's simply no way that could be held up on the merits, which is why the university doesn't really focus on it.
So I'm saying, you answered the backwards of that, but that's fine. So if we should find that there is enough chill to get you standing, you win, is what you just said.
That's essentially,
And
there are
if
two
you
separate
find there
inquiries.
isn't enough chill to get you standing, you lose.
Essentially, Your Honor.
Yeah, okay.
If Your Honors have nothing further.
All right, thank you.
Thank you, Your Honor.
All right, we appreciate very much counsel's argument in this case. We will move directly into our second case. Mayor, we're happy to hear from you.
Thank you, Your Honor. May it please the court. Your Honor, just to start off, I wanted to, on the assumption maybe the members of the court aren't super familiar with all the different types of vaping products out there, I wanted to just provide a little bit of background because it actually ends up being quite important, I think, to the court's analysis.
I don't think we're going back there and vaping after.
And there are sort of three fundamental subcategories here that are at issue. There are bottled e-liquids, which are nicotine-containing fluids, which are the only products at issue with this particular application for Avail for the petitioners. There are cartridge-based products. Oftentimes these look like those USB stick memory drive things. Juul is a familiar brand. And then there are disposable products, which are functionally virtually identical to the cartridge-based products, except instead of swapping out the cartridge that has the e-liquid in it, the entire device gets tossed in the garbage once it's expired. For all of these products, and this is important just as a background setter, FDA, it's important, these products are fundamentally distinct from combustible cigarettes in terms of the harm profile that they present. FDA itself, and this is in the TPL report, it's J34, recognizes that ENDS as a category are generally likely to have fewer and lower concentrations of harmful and potentially harmful constituents than combustible cigarettes, and biomarker studies demonstrate significantly lower exposures to those HPHCs, as they're called, among current exclusive ENDS users than current smokers. And this is otherwise in the literature review, but the Royal College of Physicians in the UK has, as a class, said that these products are 95% less harmful than combustible cigarettes. So I just wanted to set that by way of background. And Avail's target audience for these market for these products are the 37.7 million adult consumers of combustible tobacco products that they would like to have switch to their products, which are significantly less harmful. Now, why is this particular?
These are flavored, right?
I'm sorry?
These are flavored. That's what, excuse me, distinguishes them
Correct.
from things that have been approved, right?
Correct. The ones in this particular application, this bundled application, were all flavored. None of them were
Right,
tobacco
and-
flavored.
And isn't there evidence that flavored, what do you call these things? E-liquids? What do you call them?
E-liquids, exactly, Your Honor.
Okay, that
And
these flavored e-liquids are more appealing to young people.
there is evidence, but flavored e-liquids are also used, Your Honor, probably 85% to pick a round number of adults use flavored e-liquids as well. So they're used across all age groups. But the distinction is very important. And when we talk about what the Fifth Circuit Motions Panel described as the surprise switcheroo, it really can be boiled down to this. And I think this really is brought to the fore by Chief Judge Pryor's opinion in the 11th Circuit. To the extent that one wants to go down the rabbit hole of looking at FDA's 2020 enforcement guidance, on which the agency heavily relies, about what the agency was signaling about the attractiveness to youth of flavored products, that guidance was essentially saying it's cartridge-based. It's a cartridge-based subcategory of products that are particularly attractive to youth. And that's because, and the record shows this, the guidance says this, there are particular features of those that are also common to disposable e-cigarettes as
I think
well.
your argument is overlooking one thing, and that is essentially the statute gives the FDA a good bit of discretion because the pre-marketing authorization is tied to what would be appropriate for the protection of the public health. And so this seems to me that when you look at the Tobacco Control Act, that the FDA was acting in accordance with it, and it's just taking the standard of review. It's hard to see how the FDA's action is arbitrary and capricious, given the number of factors that support its decision, including the one that my colleague Judge Motz just mentioned, and that is that flavors attractive to children and adolescents because children are naturally attracted to candy and sweets, and that these flavored cigarettes may be introducing a whole new generation to nicotine addiction and smoking. And that was just one of the things that the FDA had in front of it, and I don't know what authority we have under the statute to simply throw that out and say, no, I'm sorry, you're arbitrary and capricious. I just don't see it.
Your Honor, if I can be heard on that, That's the lens through which FDA wants this court to look at this, look at the outcome. This is fundamentally a procedural challenge here. And this, let me get back to the point I was attempting to make before. FDA said prior to the September 9th, 2020 deadline to submit these applications, to the extent
It's not
FDA...
just a procedural challenge, no, it's a challenge to the denial of the pre-marketing authorization. That's a very substantive decision. You don't like it. They thought it was necessary for the public health. That goes to me beyond procedure. Now, to the extent that you're talking about procedure, you're saying, well, the FDA can't consider this type of evidence, or that it needs this type of clinical study or that type of study. But as I read the statute, it doesn't allow us to cabin the FDA's approval process into, you can consider this piece of evidence, but not that. It gives them some flexibility to apply their expertise to the what's appropriate for public health. And they come with the bottom line saying, we don't want to introduce a whole new generation of Americans to smoking and the public health risks that go along with it. I mean, you know, today's flavored cigarettes are tomorrow's emphysema wards. And that's not an arbitrary and capricious position for the Food and Drug Administration to take. And they've looked at these studies. They have more expertise than I do, for sure.
May I please finish my thought, Your Honor, because there's a very important procedural point here. In the 2020 enforcement guidance, FDA said it's cartridge-based flavored products that are particularly attractive to youth. 10 months after these applications were due, without notice to industry, and it's in the August 17th, 2021 internal memo, FDA expanded that internal scientific determination to all flavored products without giving notice to industry, without accounting for industry reliance on that. And that then was the fundamental basis for this new standard for evidence that FDA imposed for refusing to consider the marketing plans, et cetera. And so for requiring longitudinal studies that follow participants over time as opposed to single point in time studies. A whole line of
Wasn't that
ramifications
withdrawn?
flowed
Wasn't
from
that withdrawn at some point to allow for more flexibility with respect to submission of evidence?
That particular line is found directly in the TPL report, Your Honor, and I'll cite to the record. where
What
FDA
particular
expanded that.
line? I'm sorry.
It's the August 17th, 2021 internal memo that was subsequently withdrawn, but the particular line of expanding it to say all of these, no matter device type, regardless of the type of ends, all flavored products are equally attractive to youth, flowed through into the TPL report for this specific application and for hundreds of other ones as well, hundreds of other products. The specific citation is, court's indulgence here. It's the enforcement guidance was JA 105 to 106, where it talked about the disposable, or I'm sorry, the cartridge-based specific features, and then JA 31 or JA 77 to 78 was the internal memo, and in the TPL report it's JA 31. That was a switch in internal policy without considering the reliance interests of the industry, to the extent that the industry ever should have relied on an enforcement guidance as opposed to a PMTA guidance to begin with, that FDA failed to disclose to industry and that then used to prejudice industry. And the result was anything but harmless. It was entirely prejudicial. This applicant did everything that it checked every box that FDA asked for in its 50-plus page enforcement guidance, did every single study that they were requested to do. And the only reason that they were denied is because FDA failed to give any advance notice that they wanted this comparative efficacy study of the all flavored ends products against a specific tobacco flavored product. FDA cannot deny, they cannot stand here and deny that they did not change that policy.
I don't see that the agency has acted in a procedurally unwise way in this sense that they considered a wide variety of studies, and they considered a wide variety of factors. And one of them was, and I looked at this, that there were studies showing that all these sales, accessibility and advertising, you could advertise restrictions, you could try to have sales restrictions, and they were all found to be, the studies indicated that the advertising warnings and the rest were not effective in reducing youth use. And then they considered as well your view that these flavored cigarettes might reduce adult smoking. But your burden was to disprove that the FDA's conclusion was that whether they had any effect at all on the reduction of adult smoking was uncertain at best. What the point is, they didn't go off half-cocked. The agency considered a wide array of different subjects, pointing to the fundamental factor that they're introducing a whole new generation to nicotine addiction and smoking. And one of the factors that they considered were studies showing that the introduction of nicotine and smoke and the rest were having a permanent, there were studies showing that the nicotine has a permanent negative effect on developing brains. And so in light of all of this, how do we say that the FDA acted arbitrarily and capriciously under the Tobacco Control Act, whose operative phrase is that what would be that the marketing authorization should rise or fall on what's appropriate for the protection of the public health. That is a broad delegation of authority to an agency right in the very center of its area of expertise. And I don't understand what they did wrong.
Your Honor, I agree. I'm not asking this court to put on its white lab coats and stand in FDA's shoes, but any agency, regardless of its area of expertise, must abide by fundamental rules of due process, and when they change policy and shift policy, take account for regulated industries' reliance and interests. And the first point Your Honor made, yes, they made that point about, oh, these marketing restrictions don't move the needle. They made that as to cartridge-based products only. I refer the court to the Chief Judge Pryor's decision in the 11th Circuit in Biddy. That's exactly what was at issue. And in fact, what they said in the 2020 enforcement, I'm sorry, Your Honor.
No, I'm sorry, I know your time is brief. But I would have thought that the youth's enjoyment of these different products changes so quickly, so that if we said you have to do a cartridge-based product and then you can't use that rule to go forward when they're using other means, that would hamper the agency indefinitely. They couldn't move as fast as the kids do.
All we're asking for, Your Honor, is a fair opportunity to give notice to the industry and for the industry to undertake and complete the requisite studies. What happened here is this is announced after the fact in the denial order in the first instance. There's no fair opportunity.
Is there a motion for reconsideration? We certainly get a lot of them.
I'm sorry, Your Honor?
Is there such a thing as a motion for reconsideration?
They actually stayed this marketing denial order temporarily and re-reviewed and said, well, because we don't have this comparative efficacy evidence, but they couldn't go back and we couldn't go back and finish the studies or undertake new studies because they'd already denied the application.
Is there anything to prevent you from doing that now?
We could submit a new application. The problem is now these products are now off the market. They have to be off the market, and this has effectively destroyed this business. I mean, this decision has destroyed.
So
my
why are
client's
you
business.
here?
Well, because they have, in part, there are 2 other pending applications that are still there.
So it hasn't
and-
destroyed the business.
Well, it has. They've had to close all their stores. I mean, they've had to close all their stores. There's still obviously residual value potentially in these other applications, but they're still there. And to the extent that that the court remands this back to the agency with direction to allow these additional studies to be done and allow the application to be supplemented, then it may be able to get back on its feet again. But this was profoundly prejudicial. It was anything other than harmless error. And it comes back to fundamental, I point the court to the Regents case, State Farm, all these cases that are about fair warning and due process.
How many circuits would you throw us into conflict with? At least 3.
Well, Your Honor, this case is fundamentally different than all the other cases that have gone against the industry so far because
They present the same question pretty nearly.
Your Honor, no, this is fundamentally different because this is, and the Triton case is mine and one of the 11th Circuit petitions, that was my case. This is the only one so far where the applicant checked every single box that was required in the guidance that FDA provided. There was no statement, no inkling that applicants needed to make a comparative efficacy study comparing flavored products against tobacco flavored products. This case is fundamentally distinct on the facts from the cases that have gone against it. But I think the 11th Circuit's analysis is instructive here because it goes to this point of what the 2020 enforcement guidance on which FDA was hanging its hat goes to is these cartridge-based products, not bottled.
Thank you very much.
Thank you, Your Honor.
Colleagues have any questions, we'll hold off. Judge Miles. All right, thank you. We'll hear now from Ms. Conkley. We're happy to hear from you.
Thank you, Your Honor. Good morning, and may it please the court. The courts of appeals for the 5th, 7th, and DC Circuit have all recently affirmed very similar marketing denial orders.
Could you address the last point, or really the only point that he made, and so while it's fresh in my mind?
Yes, can you just remind me what that point was? I was focused on my own.
This was the business about you changed the standard midway, or yes, you changed.
Indeed, Your Honor, and all 3 of those circuits, the 5th, the 7th, and the DC Circuit, have very soundly rejected that exact same argument. The DC Circuit...
The record was exactly the same there?
That the standard changed, that they weren't put on notice of what they would need to provide?
Yes.
Yes, that was the exact same argument that was raised in all 3 of those cases. The 7th Circuit called it blatantly wrong. The DC Circuit, I believe, called it far off base. They had very little trouble disposing of that argument.
Okay, I'm happy to hear the bottom line. Now, why did they do that? What was the rationale?
All 3 of them held that the notice is right there in the statute itself. Subsection C of the relevant provision, 387J, provides that the FDA is to assess these applications on the basis of whether the applicant has made a showing based on valid scientific evidence that their specific product is appropriate for the protection of public health.
Okay, that's the only answer I had. I thought maybe.
Yep, okay, well, it launches into where I was going to go next, so I'll proceed down that path, if
Ms.
I may.
Conkley, I'm sorry, maybe I misunderstood Mr. Heyer's argument. I thought he was arguing that somehow the products at issue had been changed. He focused on the cartridge-based products and then said that all of a sudden the FDA then decided that they were going to focus on a different subset of products. Did I misunderstand that?
What he may have been referring to there is in the 2020 enforcement priority guidance that the agency issued in early 2020. At that point in time, there was substantial evidence that youth substantially favored cartridge-based products. And so the FDA noted that popularity and announced an enforcement priority that it would crack down on those specific
Right.
products.
And then he says that with no notice to his industry, his clients, the FDA pulled this switcheroo, I guess, for lack of a better term.
Well, Your Honor, in that guidance, the FDA goes on to discuss, and again, all 3 of those other circuits credited, the FDA's reliance on this discussion when it reached its ultimate decision here, that the agency had previously, back in 2018, enlisted the aid of industry in coming up with marketing restrictions, sales restrictions to try to stem youth access to these products. 2020 guidance discusses at length why all of those measures were completely ineffective. And that's, there's sort of a common sense explanation for that, which is that youth very rarely attempt to purchase these products on their own with a fake ID. Instead, they're getting them from their social networks. And so there's just sort of an inherent limitation on what those measures can do. So the FDA noted those limitations. It simultaneously announced that it would be prioritizing enforcement against cartridge-based products. By the time that it got to 2021 and was issuing the MDO at issue here, the agency is required to assess all of the evidence before it, and what that evidence showed in the interim between the issuance of the 2020 guidance when the MDO was issued was that youth had migrated. In response to the FDA's enforcement prioritization of cartridge-based products, they had migrated to disposable products. And so,
one of the things that interests me on the, I suppose, as to whether your position has been consistent. In an overall sense, it's certainly been consistent because from the get-go, it's been a question of whether the public health is put at greater risk by the introduction of these flavored cigarettes. So the overall standard, which is the statutory standard, has remained the same. Now, what we're talking about here is a field in which the evidence is not completely static. There are new studies coming out all the time about comparative risk of candy-flavored cigarettes versus tobacco-flavored cigarettes. There are new clinical studies coming out all the time. And it only makes sense to allow the agency to be attentive to the evolving science. And if every time you're attentive to the evolving science, you're going to be accused of switching your standards, that handcuffs you to a greater extent than I think the statute does. They're trying to say you can only consider this evidence and not this evidence, you can only do this and not that. But I read the statute as giving you flexibility to protect public health. If you don't do it, who will? But this is, so I guess my feeling about the standard is that the scientific evidence is evolving all the time, and that the standard has been a statutory one from the beginning, and that is for the protection of public health.
yes, Your Honor, that's exactly right. And if I could respond to that and also tie that into finishing my thought in response to Judge Diaz's question. Neither the science nor the market is static. And what the FDA saw between 2020 and more recently is in response to the crackdown on a particular type of devices, in particular the cartridges, youth migrated to a different type of device. The consistent through line that the evidence showed, the evolving evidence before the agency, is that flavor is the driving factor behind youth demand for these products.
So
That's-
if neither the science nor the market is static, under what authority did the FDA have to simply ignore the petitioner's marketing plans, if there was some possibility that those plans might be different than its predecessors?
Yes, Your Honor, I'm happy to address that. If I could offer an analogy with respect to the marketing plans, I think it might be useful to think about it as similar to an application for a driver's license for a new driver. Typically comes with a written test and then followed by a road test. It's all part of one unified assessment that the state makes as to whether the applicant is entitled to the license to operate the motor vehicle. Similarly here, you have the threshold showing of whether there's any scientific evidence that supports that the product at issue will present a net public benefit to public health. And so the petitioners here, actually, I would note that they concede on page 22 of their reply that the evidence they've submitted does not go to make that comparative showing as required under the statute. And the FDA assessed here that's sort of similar to them flunking the written test. And what the Fifth Circuit and the DC Circuit have agreed is that in light of the absolute failure to present any evidence that would suffice to meet that statutory standard, there's simply no need to move on to the road test, in my analogy, or here the assessment of the marketing plans.
In that connection, one of the things that concerned me was if we went the other way here, we would be in conflict with, as I see it, 3 other circuits. And we would, the 11th Circuit in a divided opinion, I think, went their way, but we have 3 other circuits that have essentially agreed with your position. Am I mistaken in that?
No, Your Honor, the 7th, the 5th, and the DC Circuit have very soundly rejected all of the exact same arguments that the petitioner is raising here.
So we'd be on the thin side, to say the least, of a circuit split, correct?
That's right, Your Honor. The only decision that has so far come out partially in favor of the applicant is the 11th Circuit's Biddy decision. That was a limited holding that remanded simply for consideration of the marketing plans. I would note some distinctions with that case. There was a reference there to a unique, sort of innovative restriction that was proposed. I think it was called a trace and verify restriction, in which they were advancing technology that would, if a device wound up in the hands of a child, you could trace it to the adult that it came
Well,
from.
there's a whole
So
lot
that
of
was.
evidence about the significant risk to youth of this particular product. It seems to me that a society in general has a particular responsibility to its children and to upcoming generations. We owe that to them.
Yeah.
They cannot protect themselves against this kind of, I won't say predatory, but against this kind of alluring behavior that seeks to convince them that it's no different from a Baby Ruth or Three Musketeer bar. But we owe this to them. Each generation owes it to the succeeding generations to do the best we can to make sure that they grow to adults in a way that maximizes their health. We owe this to children and to young adults. And I don't know, I have read through a lot of this record, and I see many studies and things indicating what the risk to these young people are. And I don't know what the benefits of it are. They can get the sweets, and they can satisfy a sweet tooth in many ways other than introducing nicotine into their brains and into their system. And this is a gateway thing, because smoking, there are a number of other studies that were before the FDA indicating that smoking is a habit, and that it's a habit that's formed at youth. And then once you get accustomed to the idea of a weed in your mouth, that's going to be a habit that's going to carry on through to adulthood, because most adult smokers began the habit in their mid-teen years. And that too is part of what the FDA was considering, as I understand the record.
Yes, Your Honor, and that's written right into the statute. Again, the FDA is required to conduct a balancing analysis and to assess, on the one hand, the very well-established harms that these products present to children against the potential benefits to adults. There is a very substantial scientific consensus that is laid out in great detail in the TPL, in the record in this case, that lays out all of the evidence that Your Honor was just referencing for just how harmful these products are to children, the harm that nicotine does to developing brains, the fact that essentially all new users of these products are below the legal minimum age to purchase them, and therefore they become addicted, and potentially for the rest of their lives. And the FDA has repeatedly reiterated that any potential benefit that these products may have to adults who have been using combustible cigarettes in switching over to a less harmful product absolutely cannot come at the expense of addicting a new generation going forward. That is the standard, that is the statutory standard that the FDA applied here. It assessed that consensus evidence, and it noted that because the harms to children are so great, and because it is required to conduct a balancing analysis, it's incumbent on the petitioner to meet its burden to show a specific benefit to adults sufficient to outweigh those harms.
Well,
That's a
along
product-specific inquiry. I'm sorry.
No, I just say along that line, maybe you could talk to me a little bit about the agency's changing views on the criticalness of the marketing plan. The FDA had earlier said that it was critical to the agency's determination of whether a new product is appropriate for the protection of public health. But there wasn't any consideration of the marketing plan here, was there?
Yes, Your Honor. And
And that was error, wasn't it? I mean, the question is whether it's harmless or not.
the agency does not concede that it's error. I would again, go back to the analogy.
Well, isn't the public entitled to take the agency at its word? I mean, it had said in the Federal Register that the determination, that the marketing plan was critical to its determination.
And Your Honor, it would be critical to before the agency can issue a marketing granting order, it would need to assess the marketing plan and determine that it's sufficient. In the same way that you need, in other words, both the threshold scientific showing of a net public benefit to public health and the marketing components and the back-end restrictions. They're both necessary conditions, neither is sufficient. And here, where
Well, if neither is sufficient, then you had to talk about both.
Well, but the petitioner here concedes, again, on page 22 of their reply, that the evidence they submitted does not suffice, does not go to that comparative benefit that the statute requires them to make. And so when the agency went through 5 different categories of information that are evidence, purported evidence that they submitted, the agency assessed it very carefully and in detail. It concluded that none of it, was robust and reliable and sufficient to meet that standard. In the absence of that showing, there was no need to move on to there's no need to go from, the written test to the road test in my DMV example. If you fail your written test, there's no point.
Counsel, is
Yes.
the concession that you're talking about, that your colleague on the other side made, a concession made on appeal, or one that was apparent to the FDA on the record when it decided not to consider the marketing plan?
No, Your Honor, at the point where it issued the MDO, it assessed all the categories of evidence that the petitioner submitted, and the FDA assessed that none of that evidence was sufficiently robust and reliable to meet their burden to make a showing of net benefit to public health
Okay.
for their specific products.
That's not the question you asked.
No, the question was
Oh,
whether or
I'm
not the
sorry.
concession that you highlighted was made during the process that the FDA considered whether or not to review the marketing plan, or is a concession made after the fact?
The concession was made in their reply brief before
Okay.
this.
Well, that sounds like a harmless error argument.
Sure. And I'll turn to that. There's one other quick point I'd like to make, which is just that I'd like to note that in any event, the FDA did assess a 3-page overview of the marketing plan. That's at Joint Appendix pages 312 to 314. It's a 3-page summary of their much longer 110-page plan, which the agency concededly did not look at. But the agency did assess that, similar to what was noted in the Fifth Circuit decision as part of its review. Moving on to the harmless error standard that Your Honor just referenced, the Supreme Court in the Shinseki versus Sanders case cited in our briefs has laid out a clear standard that is the applicant's burden to meet. And in order to meet that burden, to show that the error harms them somehow, they need to show some sort of probability of likelihood, some possibility that the outcome could possibly be different were this to be remanded. Here, the petitioner is not contending, and in fact, if the court were to go back and look at the marketing plan, which is in the record, it's there for all the world to see, the restrictions and measures that they're proposing are things like age restrictions. They intend to market to adult audiences only. They have special training protocols in place, and they've got age verification requirements. Those are all garden variety restrictions that the FDA, in its experience, has found to be completely inadequate to restricting youth access and demand for these products. That's discussed in great detail in the 2020 guidance, and also relied on heavily in the TPL that was attached to the ultimate decision here. So there really would be no point in remanding so that the court could consider the same standards or the same measures that it has already found generally to be insufficient. The petitioner is not making the case that it has proposed anything innovative or material or different from the general, run of measures that the agency has assessed in its expertise to be insufficient to tip the scales or make the difference, particularly in the lack of any showing that their products have a net benefit to public health.
One more word, excuse me, one more question about the marketing plan. Is it your position representing the agency that there could never be an effective marketing plan that would be, if that's so, then why say that the marketing plan is crucial?
No, Your Honor, that's not the agency's position, and it has been clear that to the extent that industry or a particular applicant proposes something innovative or material or different, then that would require a harder look. There are some applications,
Well,
I understand.
But you didn't look at it here, so you don't know whether they did.
Well, the record is there for the court to see, and we do know that there's nothing in there that was different. I can say that there are a couple of companies that are exploring some new technology known as access restrictions. My understanding is that it works similar to like using your thumb to open your iPhone. You would use it in a similar way with the vaping product, so it'd be...
So they have to be a 21-year-old thumb?
Exactly. Your Honor, this is a new innovation that certain segments of the industry have come up with. They've proposed in those applications. The FDA has, they're assessing those applications. They're under review, so I can't speak to how they'll come out. But something like that or some other innovation that could possibly tip the scale could make the difference here. And to be clear, even in cases where the applicant makes an evidentiary showing, which was not done here, that marketing plans are essential. They are a necessary component of a final granting order. It's just that you don't get to that stage unless you make that threshold evidentiary showing that your product specifically is going to provide more benefit to adults in quitting than the harm inflicted on children and addicting a new generation of nicotine users going forward. I see that I'm almost out of time, so I'll ask if there's any further questions.
Thank you very much.
Thank you. In closing, we ask that the court deny the petition for review.
I have 4 points I'd like to try and get through very quickly. First, and pardon the righteous indignation, it is absurd that counsel stands here and says that FDA reviewed the marketing plans. JA 35, we have not evaluated any marketing plans submitted with these applications. The marketing denial order, JA 12, says scientific review did not proceed to assess other aspects of the applications other than whether there was a comparative efficacy evidence, a randomized controlled trial, or longitudinal cohort study. That is not supported by the record. Secondly, on the issue of the marketing plans and the suggestion that there's nothing here that was any different than what FDA had reviewed previously, I'm going to point your honors to JA 312, which is part of the marketing plan. One thing that Avail did uniquely and differently than what FDA has pointed to in the past is they had non-descriptive flavor names that didn't describe the flavor on the labels at all. And when they did a perception study of adult consumers, they found that consumers found that tended to make the products more attractive to older adults, not attractive to youth. That was an innovative and different.
I read with some care your objections to the agency process and to the agency standard. And the reservation that I have is it seems to me you may be encouraging us to miss the forest for the trees. And the forest, in my judgment, is this statute and its discharge of responsibility to the agency in an area where the agency not only has expertise, but is dealing with a shifting and evolving situation. And it seems to me that the issue comes back to where this argument opened, and that is that these e-flavored cigarettes presented a distinct risk to the health of young adults in our society. And we can talk about this point, we can talk about that. But that's the bottom line. That's the agency's consistent position. And it seems to me we are in danger of going off the rails here and trying to overlook what is the standard of review and some deference under a fairly broad delegation of authority under the Tobacco Control Act. And I really do think that the health of the younger members of our society was what the agency started out with. It's what it ended up with. And I'm just, sometimes it's important not to lose sight of the major point.
Your Honor, if I can respond to that, and then the other point I wanted to hit here briefly. I'm concerned that the court is going to swallow the bromides that FDA is selling. We're not seeking marketing authority or marketing authorization to offer these products to youth. In fact, there is zero evidence that any youth have ever consumed a single Avail product. And unlike the cartridge-based products and unlike the disposables with their own features that FDA in its 2020 enforcement guidance, things about ease of use, rechargeability, high nicotine content, et cetera, said make those products particularly attractive to youth. That's not the case with these flavored bottled e-liquids. These are very low nicotine bottled e-liquids, and these are the products, if you look at the National Youth Tobacco Survey results, that are the lowest of use by youth. And again, there's zero evidence that any youth have ever used an Avail product. So this is for these products that Avail wants to market to assist adult smokers, cigarette smokers. Those are the people that are looking at emphysema and lung cancer and those things. We shouldn't lose sight of them, and respect, I don't think the court should either. Those are the people facing the nearest and most prejudicial harm when it comes to public health. But again, what I'm asking the court to do is to regulate and put some guardrails around an agency that does not respect fundamental due process rights here. It's not an issue of the substance.
The agency is entitled to weigh any putative benefits to older smokers against the risk to younger smokers. And it's got to make those sorts of comparative judgments, as I understand the statute. And it did. It said that the risk to the benefit to older smokers was illusory and uncertain at best, and the risk to of introducing younger Americans to these cigarettes was concrete and palpable. And that sort of comparative judgment is explicitly entrusted to the agency to make.
But Your Honor, they ignored, because they didn't look at it, the evidence of benefit to adult smokers that was found in my client's application. Like when they did a perception and intent cross-sectional survey where 18 to 25% of adult smokers said they would be interested in trying these products to potentially quit. Because that wasn't a longitudinal cohort study or a randomized control trial that followed participants over time. Again, a switch and a new demand after the fact, FDA ignored it. It didn't fit into their 10 months after the fact new imposed evidentiary requirement. Standard for evidence, as they said in their July 7th internal memo, that they imposed 10 months after these applications went in. All we're asking for is reasonable fair notice and fair warning and an opportunity to meet it. And if this court remands, as we're requesting, and directs the agency to allow us to undertake those studies, then my client will feel like they've gotten a fair shot. But otherwise, the agency can always change the rules to always deny the applications. Thank you.
And I'm sorry we can't come down and shake your hands, but I wanted both of you to know that we appreciated your argument. Thank you so much.
I'm good.
Al, you okay to go on through? Let's take up our third case.
Lena Araneta, and I'm here on behalf of Mr. Keenan Bond. The district court in the case of Keenan Bond committed reversible error because it relied on the erroneous factual and legal premise that the written plea agreement weighed against granting compassionate release, even though the plea agreement did not contain a waiver for compassionate release motions.
Was the district court permitted to look at the plea agreement?
Yes, yes, because that is part of the sentencing that you can do, or the sentencing review that you can do.
Entitled to look at it, to review it, to consider it. What was he not entitled to do?
Well, it's our position that the court gave undue weight to the plea agreement because basically the district court would not reduce the sentence in this case because it did not want to invalidate or disturb the written plea agreement entered into by the parties. The court did, however, find that Mr. Bond's excessive sentence of 32 years compared to the mandatory minimum of today, which is 14 years, does constitute an extraordinary and compelling reason for release. The order states that Mr. Bond's sentence will not be reduced because the 3553A factors weigh against it. First, it states that Mr. Bond negotiated a favorable plea agreement. Second, it states that Mr. Bond received the exact sentence he bargained for in the plea agreement. The court declined to disturb what it called the parties' carefully negotiated agreement. The problem is that the district court gave improper weight to a plea agreement that did not negotiate away the right to file a compassionate release motion. If one looks at the actual order, about 20 lines are dedicated to discussing the plea agreement, and about 9 lines.
The essence of a plea agreement that you exchange certain present benefit, the certainty of a present benefit, and you accept the risk that in the future you might have to forego the emergence of a new development. That's the whole philosophy behind plea agreements, present certainty in exchange for a future risk that something might come along that you can't take advantage of.
Correct. However, the analysis conducted by the court in this particular case essentially nullifies the changes that Congress enacted in the First Step Act of 2018.
Well, I mean, but Congress operated in, I mean, when Congress modified, enacted the First Step Act, it wasn't thinking about any one particular case, right? It was thinking more broadly about judges' ability to grant compassionate relief when appropriate. And ultimately, the district court, even after finding that there were extraordinary circumstances in this case, was then entitled to look and consider whether or not the 3553A factors, and you've conceded that the plea agreement is a relevant consideration. So what was it that the district court did wrong in considering the fact that, as Judge Wilkinson pointed out, your client, way back when, negotiated a plea agreement which allowed him to avoid liability on other misconduct in exchange for a favorable limitation with respect to sentence? Why can't the court consider all of that in deciding that, at least with respect to this defendant, notwithstanding that there was a finding of extraordinary circumstances warranting at least a look at whether or not to modify the sentence, that it simply wasn't appropriate in this case?
Well, the thing is, the court gave undue weight.
What does that mean? What do you mean by that?
So if one were to look at, for example, the scales, 2 scales, the court focused almost 75% of its decision on the plea agreement, on what was negotiated. So it gave so much greater weight to the plea agreement and what counts were later dismissed versus the actual individualized factors of the defendant.
No, I don't think so. I mean, it was, the court made the comment that the plea agreement notwithstanding, the plea agreement represented a belief as to what the appropriate sentence was, which was 32 years, and it could have been negotiated, 10 years ago or 10 years in the future. 32 years was the appropriate sentence, and you got a huge benefit out of the plea agreement, and now you're wanting not only the huge benefit, but you're wanting another benefit on top of it all. This is even given the fact that the district court, when it considered the 3553A factors, said that even if you find extraordinary and compelling reasons for compassionate release, you still have to consider the 3553A factors. And those factors included most prominently in the district court's mind the spree of armed robberies that this individual participated in. They were pointing guns at store clerks and customers and taking and pointing a gun at a customer's head and demanded to know who was in the vehicle parked outside, and the man responded his wife and child were in the vehicle. So he goes out and holds the wife and child at gunpoint while robbing the wife of her cell phone and cash. And that the severity of the crime, the need to deter the future, the need to protect society, right at the heart of the 3553A factors. And that's even putting the plea agreement to one side. I don't think the district court was wrong in considering the plea agreement. In sentencing, you have a wide range of factors you can consider. But, what you're asking for is benefit way above and beyond the considerable benefit that you received in the plea agreement.
Well, I would disagree, Your Honor, respectfully. The only reason that the plea in 2018 looked favorable was because the law at the time, if Mr. Bond had been convicted of all his counts, would have been over 1,000 months or approximately 88 years in prison. But Congress changed the stacking law because it was unjust and unfair.
But that wouldn't have stopped the district court even then from considering the other conduct at the original sentencing. If there had been no plea agreement, there still would have been wide consideration of the defendant's actual conduct, right?
Correct. But the danger in what happened in this particular case is putting undue weight onto a negotiated plea agreement, because in the end, that is what the court focused on. This is the plea the parties negotiated, and its net effect is that it nullifies the goal of Congress when it implemented the First Step Act, because pre-First Step Act concerning 924C had, with the mandatory minimums, it was 5 to 10 years for the first count, plus 25 consecutive years for the second and subsequent charges if they were all obtained in the same case. The First Step Act ended the stacking, and now the 25-year mandatory minimum applies only when a prior 924C conviction arises from a separate case that has already become final. And what Congress intended with the First Step Act is even recognized by the March 11, 2022 memorandum of Deputy Attorney General Monaco to all federal prosecutors, where it stated that plea agreements should not require broad waivers of the right to file compassionate release motion under 3582C1A. This is in the supplemental authority letter filed by Mr. Bond regarding the case of U.S. v. Blount, which is also pending before this court. Blount is further support and has additional information for the court to review. I want to point out that the government had an opportunity to respond to that filing, and it didn't. If it had a different view, it could have filed a response. It's our position to uphold that the decision to uphold the decision of the district court in this case is to essentially deny compassionate release motions on the basis of a general waiver of post-conviction rights in a written plea agreement.
Well, did the district court consider the other statutory factors?
So, very
All the
briefly,
statutory factors?
very briefly, I would say, and I've counted the lines, about 20 lines were dedicated to analyzing the plea agreement and the benefit to the defendant, and then about 9 lines or a little less was dedicated to the actual enumerated factors of individually assessing.
Well, the judge here had been the judge, the original judge.
Correct.
So the judge presumably knew the case better than you do or I do, right?
Right. I would not disagree with that. But what we're asking is to place some restrictions on going back to an analysis of the negotiated plea agreements, because without restrictions, the courts could just basically ignore the congressional intent of this First Step Act.
Well, your position is not that the court cannot consider the plea agreement. Is that right?
Correct. That is not my
The court
position.
can consider the plea agreement.
It can, but what we're asking for is some guidance as to how much weight, because in this particular case, again, 75% of the analysis was relegated to what was given up. And again, and how it may have benefited the defendant only applied because in 2018, he was looking at a potential sentence of over 1,000 months.
It's up to district courts to assign weight to evidence, and you say, well, there's no bar to considering the plea agreement. The district court just attached undue weight to it, but the whole process of attaching weight, relative weight to evidence, that's what district courts do.
But what about when you run into the situation if a judge is not in agreement with the statute, as apparently they're not with this First Step Act and the changes to 924C, and decide to use that to nullify congressional intent?
Well, I mean, there's no evidence of that, right? The court conceded, agreed that that your client was eligible, at least initially, for some relief, but then, as Judge Wilkinson points out, weighted the relevant factors in a way that you find offensive, but in a way that we find difficult to try to suggest otherwise. I mean, ultimately, it's the district court's decision.
Well, Congress did change the stacking of 924C counts. And the fact of the matter also is that the judge, if this case were to be vacated, or the order to be vacated and the case remanded back to the district court, if the district court believes that a 32-year sentence is still warranted, she can always upwardly depart and then explain the reasons for the upward departure. No one is taking that away. What we're asking is for guidance on these compassionate release motions, because other courts will be deciding these motions and putting so much weight on what is the value of a contract when it was negotiated compared to what Congress intended is in conflict, and what is happening, that this would basically make the First Step Act ineffective.
Oh, I read her opinion as recognizing the first step. I mean, that's what the first part of the analysis is. Have you read Justice Sotomayor's, I think, unanimous opinion on sentencing, recent opinion?
Yes, in Concepcion.
Yeah, and she
Right.
says that this is really up to the sentencing court. That's the whole basis, or you could consider all of these things, right? It seems to me that it pretty much forecloses the argument you're making here.
Well,
You are worried about emphasis, but I think that Justice Sotomayor told us that, and I think it was unanimous, that, this is problems for the sentencing court.
right, but the issue in that case was not similar to this. In that case, was what, the specific issue was whether a district court that was adjudicating a motion under the First Step Act could consider the other intervening changes of law, such as changes in the sentencing guidelines or changes of fact, such as behavior in prison. It held that it may. And so, again, in discussing discretion, that decision discussed evidence of rehabilitation, disciplinary infractions, or unrelated guideline changes. The issue was not whether, or it did not involve, the proper weight a district court can place on a plea agreement.
I do understand that. I really do. But the basis, the guiding line to that opinion was the discretion that the sentencing court has. Would you disagree with that?
No, and it's our position that the judge abused that discretion by putting undue weight. Thank you.
All right, thank you.
Good morning. May it please the...
Ms. Fritz?
Yes, sorry.
Pleasure to hear from you.
Good morning. May it please the court, Christine Fritz on behalf of the United States, asking you to affirm the judgment of the district court today. A district court may consider all relevant evidence.
Is there anything that we've overlooked in our questioning of appellant?
No, I think that the questioning thoroughly reflects this court's understanding of the issues and the broad discretion afforded to the district court. I would simply like to respond briefly to one point made by my opposing counsel, which was that the government's failure to respond to the 28J letter. Our understanding of a Rule 28J letter is that its purpose is to bring pertinent authorities that had been overlooked to this court's attention. We don't think it's an appropriate use of a 28J letter to attempt to incorporate briefing and arguments that were made by another defendant in another case. So our position is that the arguments properly before this court are the ones that were raised in the opening brief, and we think that this
We
court...
even have law about that. About
Yes, that is
misguided
true.
28 J letters.
Yes, but to the extent that there might be some inference that we waived anything, I wanted to make sure that I was on the record expressing my disagreement with that point. And we think that the district court here did a thorough job, conducted a holistic assessment, and it should be affirmed because it was a proper exercise of discretion. Thank you.
We have no questions. Counselor, would you like to say something in rebuttal?
Again, Your Honors, I know you understand my position. And again, I just want to say that I feel that in this case, the district court gave undue weight to the plea agreement and looked too much at what the law was at the time. Congress has changed it, and if this case is remanded back to the court, the judge can always grant an upward departure. Thank you.
All right, we thank you, and I see that you're court appointed. And I want to express Arnita, I want to express the court's thanks to you for your argument and the preparation you devoted to it. Thank you so much, and thank you both. And again, we're sorry we can't come down and greet you.
Thank you, Your Honor.
Thank you, Your Honor.
Thank you, Your Honor. Good morning. May it please the court, my name is Leslie Rawls, and I represent the appellant Escobio Rios.
I ask you to speak up, please, or maybe...
Thank you for letting me know.
There you go. Thank you.
I hope it's better. This appeal involves two issues, one of which is subject matter jurisdiction, excuse me, and the second is in sentencing error in considering an inappropriate factor. The second is an alternative. I did notice on the docket description this morning that the description of this case appeared to say that the plain error standard of review applies to subject matter jurisdiction. Of course, that's a de novo standard of review, and the sentencing error is plain error review. The subject matter jurisdiction appears perhaps to be a case of first impression. All of the cases in the other circuits that the government and I put in the briefs are more mirror images, like this court's decision in Azar, where it involves, these cases involve the application of local law to prisoners who were transferred back to the United States. And this case involves a prisoner who was transferred from the United States to Mexico.
What was the jurisdictional error that you assigned to the district court?
That the district court lacked subject matter jurisdiction because under the treaty, and this is supported by statutes and those case laws, the treaty transferred...
Are you contending the district court lacked subject matter jurisdiction?
Yes.
And what is the basis for that, given that the district court was the court that imposed the revocation sentence in the first place?
Oh.
It imposed the sentence and the supervisory release. And why wouldn't the court that imposed the sentence and set the terms of the supervisory release be the one to set a reasonable revocation sentence?
Because of the treaty between the United States and Mexico, which provides that, it's in Article 5, Section 2, when an inmate is transferred to Mexico, it's the receiving state in the treaty, but for ease of conversation, I'll just say Mexico is the receiving state, and when it's the transferring state, the United States.
But it didn't relinquish its jurisdiction when it was transferred to Mexico.
I'm sorry, I didn't hear you very clearly.
We're having trouble hearing you too, so we'll all talk up.
Okay. I'm sorry, what
I
was
was just going to suggest to you that the district court did not relinquish its jurisdiction when the case was transferred to Mexican courts. The district court still retained jurisdiction.
Our position is that it did not, that under the treaty, all of the conditions of the sentencing transfer to Mexico, including in the express terms of the treaty, any conditional release periods.
But there would have to be an explicit statement from Congress that the district court was divested of jurisdiction. And this is the same Congress that passed the Sentencing Reform Act and the revocation powers and revocation of supervisory release. And you're saying that the same Congress, or that Congress, having passed the Guidelines Act and the supervisory release conditions, somehow meant to divest the district court of jurisdiction? It seems to me the district court was conferred jurisdiction.
The treaty says it's transferred, that the completion of the sentence is transferred to Mexico in this case, with certain limited exceptions. But it says that it was transferred. The treaty was ratified by Congress, and
It was transferred, but the Article 6 of the treaty said that the transferring state retains, quote, exclusive jurisdiction over any proceedings to challenge the sentence. And so Mexico would have retained jurisdiction, we retained jurisdiction, and the treaty says that explicitly. So I'm saying, what I'm suggesting is that given the combination of the sentencing guidelines that Congress passed and the treaty and the explicit language in the treaty itself, how is there any divestment of jurisdiction?
The treaty, Article 6 that you cite to, says that the United States courts retain jurisdiction over any proceedings to challenge, modify, or set aside the sentence. That's one of the places where jurisdiction is retained. Revoking the sentence is not a modification of the sentence. Revoking the sentence results in creating an entire, in this case, entirely new sentence. It didn't change his sentence. And in the statute, in 1835-83E, it talks about modification of conditions for supervised release and revocation. And the statute title, which has to be read as part of the statute, separates those two things. So it's modification of conditions or revocation. And then parts of the subsection deal with modifying conditions, and one deals with revocation. If we shift the facts a little bit, say the United States District Court included a term in the supervised release period that the defendant had to engage in a particular substance abuse treatment program. And then the inmate was transferred to Mexico under the terms of the treaty, and that substance abuse program was not available there. Could the district court fairly then conduct a hearing? I'm just going to imagine he winds up back in the United States legally and leave that question out. But could the United States District Court then revoke his supervised release because he failed to engage in a program that was part of one of the conditions of supervised release? The scenario is different, but the premise is the same, that the conditions of supervised release are expressly delegated to the Mexican court under the treaty. And the treaty is, in the Medellin versus Texas case, the Supreme Court said that when a treaty is ratified and self-effecting, that is, it doesn't need any more legislation in order to be put into effect, then it becomes the law of the land.
I don't see how your position squares with Article 6 of the treaty, which seemed to me to say in fairly explicit terms that the transferring court here, the United States, retains exclusive, and I'm quoting the words, exclusive jurisdiction over any proceedings to challenge the sentence. How do you get around that?
Well, it's challenge, modify, or set aside the sentence, and I believe if we look at them separately, what happened was there was no proceeding to challenge the sentence. There was no proceeding to set aside the sentence. The proceeding was to revoke the supervised release period. And at best, that might come under the modification clause. But when we look at the statute governing modification or revocation of post-release supervision periods, this word modified does not match the statute, and therefore my argument is that it doesn't apply, that particular provision.
So, Article 5, Roman numerals are never my strong point, not sure what is, talks about jurisdiction.
Yes.
And none of these other provisions in the treaty use the word jurisdiction. And your argument is about jurisdiction, right?
Yes, Article 6 talks about, are you talking about the provision?
That's what I have,
exclusive
Article 6.
Okay,
Talks about jurisdiction, which Judge Wilkinson was talking to you about.
yes.
Not particularly helpful to you. So looking at Article 5, is there anything in there that talks about, which I thought you were getting you were relying on Article 5.
So Article 5, Section 2 is the basis for the argument,
Right,
because it says completion of the sentence shall be carried out according to the laws and procedures of the receiving state,
right.
including reduction of the term of confinement by parole, conditional release, or otherwise.
Right? But your whole argument why you, because this argument wasn't made below, your argument has to be jurisdiction is lacking here. And that's what it is, good for you. But the only place in the treaty that we're concerned with that talks about jurisdiction is Article 6.
That's the only place that the word is used, but when Article 5 talks about Mexican law applying to, or the receiving state's law applying to the completion of the sentence, all the terms and conditions of the sentence, the only thing they can't change is the total length. When the term sentence is used in the treaty, it's talking about both confinement and conditional release. So the receiving state cannot increase or decrease that total term, but it does determine the period of release when there's a conditional release, and as the judge noted in the district court, the release here occurred before he would have been released from United States custody.
Ms. Rawls, the Article 5, Section 2 begins with a qualifier or a modifier that says, except as otherwise provided in this treaty, right? So it suggests that there might be another avenue by which a sentence could be changed or adjusted. And then we have Article 6, which you've talked about, which gives exclusive jurisdiction to the transferring state. And then it says, regardless of their form, to challenge, modify, or set aside sentences. So given that broad, capacious language that suggests it doesn't matter how you describe it, so long as there's some change in the sentence, why wasn't the district court within its authority to revoke supervision given the broad language of Article 6?
Because revoking supervision is more than modifying. It involved creating a new sentence. And so it's different than just modifying.
Well, it is a change,
sentence.
isn't it, of sorts, in a cosmic sense?
It is a change in the cosmic sense, yes. But the treaty has a few places. In Article 5, Section 2, it also says pardon or amnesty is one of the places where the United States would still retain jurisdiction. So if this had been one of the marijuana cases that President Biden recently created a pardon for, then he would have been pardoned if the original case had. But our position is that the revocation of the supervised release and the creation of a new sentence was not a modification as allowed under the statute and under the treaty. So, and I'd like to briefly address the second issue with regard to the, if you don't have any other questions, with regard.
I have a lot of questions. I mean, I think this is a really difficult question. This is all you have to tell us. I don't think that the second question is very difficult, but you portion your argument as you like.
Okay. Do you have specific questions you want to ask me about that?
I think I've asked all the questions I can try to come up with.
Okay.
So go ahead and talk about this.
Well, in the Azar case, this court dealt with the mirror image, and this is discussed in the brief. And there is no split in the circuits about this, because this, as far as I can tell, and the government noted that it's not in either of our briefs, this argument has not been presented before in any of the circuits. The subject matter jurisdiction, I was sticking with the first argument. In Azar, this court said that even though an inmate had received good time and on a sentence that was imposed by the United Kingdom, when she came to the United States, she was not necessarily entitled to that credit. And she had objected and appealed because the parole commission refused to give her that credit. So this court has looked at the mirror image of this case and said the other court's laws don't apply, United States laws apply. And with that rationale, the same thing applies to a transfer to Mexico. The United States laws and decisions don't apply, with exceptions, obviously. But the Mexican laws do, including on the terms of conditional release.
All right, thank you. Ms. Enright?
Thank you, Your Honor. May it please the Court, Anthony Enright for the United States. The District Court had subject matter jurisdiction to revoke the supervised release that it imposed. The statutes, 18 U.S.C. 3231 and 3583, confer that jurisdiction to revoke supervised release, and that continues until the supervised release terminates or expires under this Court's precedent. Nothing in the 1976 treaty with Mexico purports to limit that jurisdiction, let alone does so by a clear statement. It states, I have the actual treaty here, but I thought I could read it at that distance. I can't. The completion of a transferred offender's sentence shall be carried out according to the laws and procedures of the receiving state. But that's an entirely separate issue than jurisdiction. The court, a clear statement doesn't have to use the term jurisdiction, but it ordinarily has to refer to the court's adjudicatory capacity. This kind of claim shall not be entertained. The court shall not consider. Something along those lines. In addition, it has to be mandatory language, and there usually has to be something special in addition to the mandatory language.
Shall be considered, isn't mandatory.
Shall be considered, certainly. I think that would be, would be.
It says shall be considered.
I'm sorry, Your Honor, I'm maybe misunderstanding what I'm not sure what passage you're referring to, but I'm happy
I'm
to.
sorry, I misread it. That's because my eyes are going on me. Shall be carried out according to.
Right, Your Honor. And what you have.
What does that mean then?
Well, I think it means that the sentence will be executed, and he's transferred to Mexico, and so he'll serve it in a Mexican prison. Mexican authorities won't have authority to determine the total length of the sentence, which is the combination of incarceration and, for example, parole. But Mexican authorities ordinarily would have the authority to decide that he'll serve part of that sentence on parole. We do the same thing when people are transferred here. But there's nothing in the treaty that really allows the Mexican authorities to say, relieve someone of the sentence that was imposed here. And I think more importantly for this case, there's nothing in the record or elsewhere that suggests Mexican authorities purported to do that. But if Mexican authorities did, and I'll respond to the hypothetical my friend mentioned, which is, well, I was sentenced to a specific drug treatment program, wasn't available in Mexico. What's the district court supposed to do? That would be a merits question. So if your defense is, I couldn't comply with that obligation because I was in Mexico or because something the Mexican authorities did relieve me of that obligation, that would be a substantive question of who wins under the law. And that would be a question for the district court in the Western District of North Carolina to resolve in a proceeding to revoke supervised release. It doesn't speak to an absence of jurisdiction over the question.
Are you familiar with the Department of Justice's Justice Manual?
Yes, Your Honor.
Okay. And it says that when a prisoner is transferred to another country, the sentencing court loses jurisdiction over the prisoner's sentence in violations of the terms or conditions of the original sentence, including supervised release, cannot be enforced by U.S. courts.
Your Honor, I have to admit I didn't see that provision. I am familiar with the Justice Manual, and I apologize because that's something I should have been prepared
Section
on.
9/35.014. You know, I'm going around reading that Justice Manual all the time. Actually, my law clerk found it.
That's a fair point, and I do apologize because I absolutely
So
should
what
have
do you have
known
to say
that.
about that?
Well, it doesn't. It's not a statute, which is probably the first answer.
So it's wrong, is that it?
I don't know that it's wrong, Your Honor. I'm almost certain it's not speaking to this scenario where a person comes back, because in the ordinary case. And I
It
would
goes
say,
on to say, this is true even if the prisoner returns illegally to the United States after satisfying the sentence in the foreign country.
I have to say, Your Honor, I really wish I had spotted that before you did, but I did not. That is not my understanding of the statute, simply because there's rules governing what qualifies as subject matter jurisdiction. Now, the one suggestion I would offer is that jurisdiction's often used in a loosey-goosey way. And I'm not necessarily suggesting that the Justice Manual is using it in that way, but what this court ought to do is follow the precedent governing what qualifies, how you determine whether a court has jurisdiction. The second point I want to mention is this other language in the treaty, Your Honor mentioned also, which is Article 6, which refers to exclusive jurisdiction. If the treaty itself, and it, by its terms, the treaty is not self-executing. Article 4 says it requires implementing legislation. But to the extent the treaty speaks about jurisdiction, it does so explicitly, especially when it's speaking about exclusive jurisdiction.
Well, in any of the provisions that we are applicable here, where does it talk about jurisdiction?
It doesn't. And that's why, that I think is dispositive.
Well, it does, it does one place that helps you, and that's in Article 6, right?
Oh, yes, Your Honor, that's what I was referring to. I'm sorry. When I thought you meant the article the defense was relying on. Article 6 speaks about jurisdiction and exclusive jurisdiction, and it reserves it to us. And that does two things. One, it suggests that Mexico probably didn't purport to modify this sentence. And two, it tells us that when the treaty speaks of jurisdiction, it uses that term. And when it speaks, and even jurisdiction, Your Honor, doesn't need to be exclusive. So, for example, if there's jurisdiction in Mexican courts, that doesn't mean that there's no jurisdiction in United States courts. Here, when it speaks of exclusive jurisdiction, that's what it means. But the fact that it didn't use that language when referring to the authority of Mexican laws to determine how the sentence should be carried out tells us that that is more evidence that that's not a jurisdictional provision. And finally, to the extent there's a conflict between the Treaty of 1976 and the Sentencing Reform Act of 1984, which explicitly and without qualification grants jurisdiction to the sentencing court to revoke supervised release, it's the later in time statute that governs. I do want to turn to the second issue, which is whether the district court plainly erred by considering an impermissible factor, by considering the history of the defendant before he returned to the United States. And the answer is no. The district court was very clear that what it was punishing as a sanction and considered to be a particularly egregious breach of trust was the defendant's violation of law, of the United States law, and violating the conditions of supervised release after receiving what amounted to leniency because he was let out of prison earlier than the court expected. And the court made that clear. It said it's the prerogative of the Bureau of Prisons and the Mexican authorities to do that, but the defendant really stuck a thumb in the eye of those authorities by coming back promptly when being given leniency. And this court's precedent is, there's plenty of decisions I cited allowing district courts to give significant weight to violation in the face of leniency and consider that a significant aggravating factor. The district court did that properly, did not consider an impermissible factor, and imposed a substantively reasonable sentence. If the court has no further questions, and if it does, I'm happy to answer them, but if it doesn't, I'll yield the balance of my time back to this court.
Do you have any questions? Diana?
So briefly, if I could address the second issue that counsel raised with regard to the court's consideration of the early release by Mexico. It's clear that under the treaty, and actually the judge said it, Mexico had the right to release Mr. Rios before his time would have expired in the United States, that was the prerogative of the receiving state. The court also made it clear that it was sentencing him to a significantly higher sentence than the guidelines because it was an early release. And the court said that repeatedly. Well, he shouldn't even be out. I don't have the transcript, I'm sorry, I'm paraphrasing. He shouldn't even be out yet, but the Mexicans let him out, and he came out early. And he does say the things that Mr. Enright said. The judge did say that it was sticking the thumb in the eye by coming back to the United States. But the emphasis in that part of the transcript is on his being released, and it's during the sentencing arguments, and it's during the sentencing itself. The emphasis is on his being released before he should have been. And I say should have been under the sentence he would have served if he had stayed in the United States. And that was the emphasis of the court. I think I've covered the rest of my argument, but if you have any questions, I'd be happy to answer them. Okay, so we just ask that the sentence be vacated, and if there's no subject matter jurisdiction, remanded for dismissal, and otherwise
Thank you.
remanded for,
We have no further questions.
thank you.
Ms. Rawls, we appreciate you, I see you court appointed. We appreciate the diligent efforts you've made on behalf of your client.
Thank you.
I'll ask the courtroom deputy to adjourn court.
This honorable court stands adjourned until tomorrow morning. God save the United States and this honorable court.